Hi, my name is Joanna Ford, and I am the Senior Family Law Attorney at General Counsel PC. I am here today to provide you with the top 10 things that you need to know before filing for divorce in Virginia. The first thing to know is that there is a residency requirement, meaning that either spouse, either the plaintiff, the filing party, or the defendant, the non filing party, needs to have been a resident of the Commonwealth of Virginia for at least 6 months prior to filing. Secondly, there is a requirement as far as grounds. You need to state in your complaint for divorce the grounds in which you are filing for divorce. And there are a few things that you can state here. And most typically, this is based upon separation. And the separation requirement is 6 months if you have no minor children and 12 months if you share minor children. And what qualifies as separation? There are statutes that can assist you with knowing how to qualify for that. If you're living under the same roof, there are ways that you can actually be considered separated and get that separation period going, even if you are still living together. The third thing I'll tell you is that you have an opportunity to do an uncontested divorce. So if you've met the required separation period and you also meet the residency requirement, you're able to file an uncontested divorce, which means that the grounds that you're stating are just the separation. And you and your spouse have come to an agreement regarding the division of the assets and liabilities of the marriage. You've reduced it to writing. You have a property settlement agreement. That includes the division of assets and liabilities. Also, if there are minor children involved, regarding child support, custody matters, and that has all been reduced to writing. Both parties have signed, and you file that when you file your uncontested divorce. Next would be how child custody and visitation are determined. So there are two types of child custody in Virginia. There's legal custody and physical custody. Now, legal custody is when one parent is making important health, educational decisions, and physical custody is where the child is physically residing with which parent and when. The sixth thing I'll tell you about is child support. Now, child support is something that there is a program that is preferred in the Commonwealth that we essentially type in, the incomes of the parties and other relevant things. And basically, depending on the type of custody that we have, the amount of time that the child or children are spending with each parent, it provides each month by the payor, and that is something that is required. And how spousal support is determined is number 7. Now, spousal support is something that there's a statute that gives a bunch of factors. And some of those factors are, if one party went to school during the marriage and the other party stayed home, being a homemaker, maybe delaying their own education or, proceeding forward in their career to allow the other spouse to, go to school and build their career. Those are things that get taken into consideration with spousal support. Obviously, the incomes of the parties, the needs, things like that. And there are a few different types of spousal support. There's just the traditional payment, usually monthly, but, the amount and duration could be discussed and either determined by the parties or the court. And also there's like rehabilitative, which could be if one party wants to go back to school and have assistance maybe with tuition or things like that. So there's a lot of room to discuss regarding spousal support. Separation agreement. So this is something we just talked about. This is number 8. And essentially a separation agreement, like we said, reduces to writing the agreement of the parties regarding the assets and liabilities of the marriage that need to be distributed, and also any children's issues, like we said, child support. So prenuptial and postnuptial agreements are number 9. So a lot of times we'll prepare a prenuptial agreement, and that's a document that's prepared before parties are married. And in the event of divorce, this is what we would follow if we needed to proceed forward with divorce, rather than looking at the laws of the state in which the parties are getting divorced. Now, a postnuptial agreement is something that can be prepared, And that is when the parties are already married, but they come to an agreement while still married, that if they do decide to proceed forward with divorce at some point in the future, then this document would be followed rather than just traditionally the laws of the state in which you are getting a divorce. And lastly, a couple can choose to do alternative dispute resolution, such as mediation. And mediation is where a neutral third party is there to assist to try to help facilitate an agreement. They can't provide legal advice, so I always recommend having an attorney with you if you can, and always seeking an attorney's advice prior to signing anything. Those are the top 10 tips I can give you. If you have any further questions, please feel free to reach out to me. I'd be happy to answer any questions. Again, my name is Joanna Ford with General Counsel. Thank you so much.